Can you remember having a case that you followed because it's likely going to change your practice? Well, we think we have one that we'll be discussing today. Hi, I'm George R. Meyer. I've learned much along my patent journey of about 30 years. With these videos, I hope to share what I've learned along the way that will help you with your practice. Subscribe to this channel so that you don't miss any of my videos. Okay, let's turn to today's topic. In this part 2 of American Axle and Manufacturing versus Neapco Holdings, we will be addressing the majority opinion from the rehearing opinion, and we will also be hearing the concurring opinions from the motion for rehearing en banc. And in all of these opinions, these judges were saying that the subject matter of Claim 22 in American Axle is not patent eligible. Let's start out with the procedural posture of the case. The original Federal Circuit decision was issued on October 3rd, 2019. On July 31st, 2020, the motion for rehearing by the three-judge panel was granted and the opinion was slightly toned down. The petition for en banc rehearing was denied in a heavily split court. This ended up being 6-6, and there were many concurring and dissenting opinions. Currently, there is a petition for certiorari before the Supreme Court, and the court has requested input from the USPTO, and that occurred about May 3rd, 2021. So this shows us that the Supreme Court is very interested in this case. It doesn't mean that certiorari is going to be granted, but it means that the court is very seriously considering hearing this case. We'll do a quick technology overview. This was hit in the first of the series, so I'm not going to cover it too extensively here, but the focus is the propeller shaft 20, which is near the center of figure 1. There are 3 types of vibration that they address in this patent, including bending, shell, and torsion vibrations. Figure 4 gives a general view of what the propeller shaft would look like when it has 2 liners within the propeller shaft. And figure 8 includes an overall view of one of the liners, which you can see is a hollow tube, and it's formed of multiply cardboard and has an elastomeric lip that sticks out and goes helically around the tube. For the most part, the disclosure is focusing on adjusting the mass and stiffness of the liners 204. Well, that's mostly the core 310, the intermediate members 312, and the cover member 314. We only show the resilient member 302 so you know what that helical member looks like from a cross-sectional standpoint. But again, most of the composition is going to be with the elements 310, 312, and 314. Let's take a quick look at Claim 22. It has a fairly long preamble, and I have not included it here. But we do have providing a hollow shaft member, tuning a mass and a stiffness of at least one liner, and inserting the at least one liner into the shaft member, wherein the at least one liner is tuned to absorb shell mode vibrations and tuned for destructive interference of bending mode vibrations. To absorb is my language. What they say in the patent claim, I believe, is resistive attenuation, and where I have destructive interference, they generally refer to that as reactive attenuation. But I'm calling them absorbing vibrations and effectively generating destructive interference so that a reader has a better understanding and can visualize in their head what's going on. Now, Claim 22 addresses both shell and bending mode vibrations. Now, the evidence appears to show that a person of ordinary skill in the art knew how to tune So do we really have an enablement issue? Now keep in mind, we also have two active steps. And the reason why I say that is that can come into play with respect to 35 U.S.C. 112F. There are some cases, this is not a holding, but there have been cases where courts, including the Federal Circuit, has expressed that they may not consider providing as truly being a step because nothing's going on. It's just a statement that something is there. Let's turn to Claim 8 in Morse's patent. Now this is the telegraph patent, and most of you who have taken a patent law course remember this case. This Claim 8 is the use of motive power of the electric or galvanic current, which I call electromagnetism, however developed, for marking or printing intelligible character signs or letters at any distances. Now, the other claims in Morse were omnibus claims, and they were held to be patent eligible. Claim 8 was not. Well, what's the difference? All you have to do is where it says however developed, remove that, and in its place put as illustrated and described herein. That's an omnibus claim. And while people may think that's broad, they are very, very narrow. They are limited to the specific details that you give within the patent. A claim may not preempt abstract ideas, laws of nature, or natural phenomena. Now, one other thing to note in Claim 8 is that it has one active step. Remember that 35 U.S.C. 112F requires a combination. I believe there's a case on a single means claim that was found invalid because it wasn't a combination. In the majority opinion for rehearing, the court stated, "We conclude that independent claim 22 of the 911 patent is patent ineligible under Section 101 because it simply requires the application of Hooke's law to tune a propeller shaft liner to dampen certain vibrations." The majority asserts that the goal is to tune the liner. But if you read the patent, the goal of the patent appears to be to reduce noise. And this is early on in the patent, that vehicle manufacturers and their suppliers are under constant pressure to reduce noise to meet the increasingly stringent expectations of consumers. So really the 911 patent discloses reducing noise by reducing vibrations, and from a practical perspective, this is achieved by tuning at least one liner by adjusting the mass and stiffness of the liner. That pretty much comes from Claim 22. The majority further states that many of these cases, in what happened in the opinion is many of the recent Section 101 cases were recited. Many of these cases having result-focused functional character of claim language involved in the abstract idea category, the same principle necessarily applies to natural law cases. What the court is saying that all these cases we have on abstract ideas also apply to natural law cases. Now we have yet another quotation from the case, and it states, "What is missing is any physical structure or steps for achieving the claimed result." The quotes sound like the courts want corresponding structures or acts. So is 35 U.S.C. 112F being merged into the 35 U.S.C. 101 analysis? I mean, simply, isn't tuning step plus function? In many of the dissenting opinions, both in the rehearing opinion and also in the motion for en banc consideration, a lot of people were saying the court is now requiring enablement on steroids, and there were other issues of enablement. But is this really an enablement issue? It probably is not. There is technical material on reducing vibration of rotating hollow tubes. Now keep in mind, what happened in this case is that a motion under Federal Rules of Civil Procedure 12b6 was filed, and that was granted. A Rule 12b6 motion is where the court states that your complaint does not have anything where we can grant relief, so we're going to dismiss it. But they did so under 35 U.S.C. 101. They never got to the point where they heard anything on 102 or 103 or 112. And if those came into play, then enablement and other issues would come up. Other than Judge Chen, all other judges with technical backgrounds voted for rehearing en banc. Now, some of this dissent characterizes the majority as creating a nothing more test, because what the majority was saying is that this claim 22 is nothing more than Hooke's law. And the majority is denying this, but it's going back and forth. Now, Judge Chen's concurrence relies heavily on O'Reilly versus Morse. That's the telegraph patent. That was that claim 8 that we had earlier. AAM is merely using Hooke's law for tuning mass and stiffness to match vibration frequencies. Now, if certiorari is not granted at the Supreme Court, this is probably the most important quote from the case, and that is, the lesson to patent drafters should be clear now. While not all functional claiming is the same, simply reciting a functional result at the point of novelty poses serious risks under Section 101. Us patent practitioners need to be careful of this when we're drafting cases. You may not want to have functional language at the point of novelty, or if you do, treat it as though it is a 112F issue, even if you never say means plus function or step plus function. And with that, that marks the end of this brief review of the majority and concurring opinions. Our next part 3 will be addressing the dissenting opinions. If you like this video, give us a like and leave a comment. Remember to subscribe to this YouTube channel, or better yet, sign up for our email list at georgermeyer.com and get a freebie. Follow us on LinkedIn. Thank you for your time, and check with us again so you can see part 3. We'll see you next time. Bye.